Good afternoon and welcome to the 2019 Anne Baum Memorial Lecture in Elder Law. This particular lecture series has covered the waterfront of elder law, which is oftentimes defined as anything that is disproportionately or exclusively related to older people. Today's topic actually is a topic that has never been addressed either in the lecture series or in the Elder Law Journal that typically publishes these speeches and lectures. That is namely the question of medical malpractice involving older people. And I'm particularly delighted that we have a special guest who is an expert in economic and statistical analysis of these kinds of issues. David Studdert is a professor of law and of medicine at the Stanford Law School. He is going to be presenting this topic, and I hope you will join me in welcoming Professor David Studdert.
Thank you. Thanks, Richard. It's great to be back in Champaign. I was sort of searching back through my emails and old CVs. I was here on campus in 2005, and at that time, the Fighting Illini men's basketball team had just lost, and it was a big game, and the room seemed a little glum. After that excellent win over Northwestern last night, I'm hoping you guys are going to be a bit more buoyant today. I want to thank the Baum family for making this lecture series possible. Elder law is really an important field of study. It's also a field that has not received enough attention from legal scholars. Richard is one of the pioneers in the field and has been an important figure in explaining to the rest of us in the legal academy that this is a neglected area, and unfortunately so. The surprising lack of attention idea is a good banner for the topic that I want to talk about today. Over the last 30 years, there's been extensive study of the performance of the medical liability system as a whole. To the extent that there's been any kind of targeted studies trying to understand how well the system works for particular subgroups, that's almost always been subgroups of physicians or hospitals, not subgroups of patients. Only a handful of studies have examined how elderly patients fare as a separate and distinct group. And that is unfortunate, not least because the elderly are by far the greatest users of healthcare services in this country. They are also, as we shall see, disproportionately likely to experience harms from medical care. When it comes to tort litigation, therefore, they are in several senses vulnerable patients and vulnerable litigants. And yet, this is still a grossly understudied area. I was thinking, as I flew in yesterday, imagine a study of the effects of video game playing on the mental health of the population, that looked at the population as a whole, didn't try to isolate the effects on teenagers like my daughters. That analogy is imperfect, but it's not a bad illustration of the research approach that has produced most of what we know today about the performance of the medical liability system. Empirical scholarship on the medical liability system has developed over the last 20 years or so a standard set of metrics for taking the temperature of things and understanding the state of affairs. Today, I want to train those metrics on the elderly. As best I can tell, that hasn't been done before. It's been done in a piecemeal fashion, but never in a coordinated way. And I was delighted for the opportunity to have a reason to pull this sort of data together. A couple of preparatory remarks about how I propose to do this. It's almost always difficult to use empirical scholarship to arrive at firm normative conclusions. Do the elderly sue too little or not enough? Are they undercompensated or overcompensated? Data can't definitively answer those kinds of questions. What data can do in an inquiry like this one, however, is show relativities. Do the elderly sue less or receive less compensation for their harms, all else equal, than similarly situated younger patients? Those are more practical empirical questions because they don't summon the same normative issues. And because a fundamental tenet of the civil justice system is equal access and treatment, answers to those kinds of relative questions can help us quite a lot in drawing useful legal and policy conclusions. So much of my analysis is going to centre on those relativities. Some of what I'll discuss synthesises prior work by my group and by others, but most of it comes from original data analysis that I did for this paper. The new analyses are mostly of the public use data set of the National Practitioner Data Bank. Now, I won't assume that everyone in the room knows what the National Practitioner Data Bank is, so let me say something about it. It's a federal repository of information on paid malpractice claims and disciplinary actions against all healthcare practitioners in the United States. It's operated by an arm of the Federal Department of Health and Human Services. Any entity that pays a claim on behalf of a health practitioner is legally obliged to report that and details of that claim to the databank. The databank has been collecting reports since September 1990 and currently has several 100,000 of them. My analyses focused on malpractice claims against physicians, which account for the lion's share of paid claims against health practitioners because physicians are much more likely than other health practitioners to experience claims. There are a couple of limitations about this data source that I want to flag at the outset. First, the databank captures only claims that result in payments, not those that don't. About 30% of malpractice claims result in payments. Second, the databank, with its focus on claims against health practitioners, omits quite an important type of defendant for elderly patients who are injured, and that is nursing homes. I won't be able to say anything about claims against nursing homes. Some of our other work has considered that. Today I'll be talking about claims against physicians. Despite those limitations, the databank is easily the most comprehensive source of information on malpractice claims in the United States. It's become the standard for population-wide medical malpractice research, and I think we can learn a lot from it. So let's start with just a few minutes just outlining the broader climate in the medical liability system. It's an interesting moment. I hope everyone can see these slides. It's an interesting moment. In the early 2000s, claim rates and physician liability insurance premiums spiked. That's sort of the left side of the slide you see here. It was the third medical malpractice crisis of the last 50 years. Since then, claims have decreased by about 60%, an average annual decrease of about 5% per year. We haven't seen anything like this before. As claiming activity has slowed, payment amounts have held fairly constant. The blue line in this chart shows median payment levels over the last 15 years. Now, payment levels are not born equally. High-end awards cause particular concerns in the health policy community because of their potential to destabilise liability insurance markets. That's often what precipitates so-called crises. What we see, though, is flatness there. The upper line in this graphic is the 75th percentile of payments. There's a little perturbation there, but for the most part, it's flat. But the most instructive barometer for understanding the medical liability climate by far are the premiums that physicians pay for liability insurance. They are an excellent indicator because they operate as a sort of vector for the amount of claiming that's occurring, for the level of money that's going out the door, and most importantly, for insurers' forecasts of the liability insurance environment into the near future. These charts show you average premiums for 3 specialty groups: internists, surgeons, and OBGYNs in 5 liability insurance markets across the country. It's a busy graph, and I don't expect you to take it all in. The bottom line is that premiums, like payment levels, have been mostly flat. We've even seen premium reductions for specialists in some areas, and that's almost unprecedented. Turbulent periods in medical liability insurance markets tend to be cyclical. In the mid-70s, mid-80s, and early 2000s, there were these surges in claims and liability insurance premiums that came to be known as medical malpractice crises. If you're a plaintiff's attorney, I guess they were medical malpractice jubilees or something like that. But these events had physicians in the streets agitating for relief in the form of tort reform. Many state legislatures passed tort reforms in those moments. For example, about half the states enacted caps on non-economic damages. Because liability insurance markets have been calm in the last 10 to 15 years, and because earlier rounds of tort reform were so pervasive, there's been relatively little tort reform over the last 10 to 15 years. A few states that didn't have some of the tort reforms have enacted them, but not many. Tennessee and North Carolina have adopted caps, while Supreme Courts in Florida and Missouri have struck down caps on state constitutional grounds. There have been a few other kinds of traditional tort reforms, like new rules for expert witnesses and so on, but again, mostly fairly placid activity in the tort reform front. We have seen, however, growing interest in experimentation with more innovative types of reforms, various forms of alternative dispute resolution, safe harbours for compliance with accepted practice guidelines, and a variety of other interesting initiatives. Time doesn't allow me to dive into these, but I'd be happy to come back to them in the Q&A because I think they have some relevance for the population we're talking about today. So with that 30,000 foot view, let me go to that population, the elderly, and start in on the question of how they're faring in this climate. As I mentioned earlier, the field has converged on a standard set of metrics, and I'm going to apply them to this group. And let me map our pathway in doing that by unbundling that large question into a series of sort of smaller questions. Starting with the question of how common malpractice claims are among the elderly. Here's that chart of paid claims you saw earlier. I've added lines now showing counts of claims since 2004. Among 60 to 69-year-olds and among 70-plus-year-olds. It's difficult to see any sort of trend line there because it's so low. For what it's worth, it's a decline, more modest than the overall decline in claims, but nonetheless a decline. However, this is not a very informative way to look at tort claims frequency because it takes no account of the size of the underlying population in any of these groups. For that, we need rates, not counts. So let's go to rates. Here are some rates denominated by the size of the US population in each of these 4 age groups. It suggests that the elderly are not out of step with the rest of the population in their rate of claiming for medical injury. But we still don't have the right numbers. Using head counts as our denominator for the rate is very, very crude. It doesn't recognise the fact I mentioned a few moments ago that the elderly are by far greater users of the healthcare system. In the parlance of epidemiology, the elderly therefore have greater exposure to the risk of medical injury. So a sensible rate measure is going to need to take some account of that heightened exposure. Here are the rates of claims per 100,000 inpatient stays, hospital stays. Now, with a more sophisticated denominator, the story starts to change. Patients aged 60 to 75 years old have 2/3 the claim rate of middle-aged adults, and patients over 75 have 1/3 the claim rate. In other words, relative to younger adults, the elderly appear to be substantially underrepresented in paid medical malpractice claims. I reconstructed these rates using several other measures of healthcare utilisation that arguably are more refined than simple stays in hospitals. The chart on the left here shows paid claims per 100,000 hospital days, so it's a more refined exposure measure. And the one on the right shows paid claims per 100 million hospital costs. Cost is an interesting measure because it gets at not only how long people are spending in hospital, but also how intensively they're being treated while they're there. But the story across all 3 of these utilisation measures I've showed you is actually pretty consistent. 65 to 70-year-old patients claim about 2/3 the rate of their younger counterparts, and patients older than 74 claim at about 1/3 the rate. I'm still not entirely satisfied with the denominators here. What is the right denominator for understanding these differential rates of claims? We've looked at these ones so far, but let me remind you what the medical liability system is supposed to do. It's supposed to compensate patients who've been harmed by negligent care. Given that, the right or the ideal denominator should really be medical injury, right? We want to know what rates of medical injury occur in each of these different age groups, or even better, rates of medical injury caused by negligence, to really understand the differentials here. The idea here is that the differences between these rates, if we take a sort of skeptic's standpoint, might actually explain away these differences. If we adjusted for the rates at which people were being injured in these age groups, then maybe they're actually all the same. For that to be true, elderly patients would need to experience lower rates of medical injury than younger patients. How plausible is that? It's totally implausible. What we know about the epidemiology of medical injury tells us that the opposite is true. The best population estimates we have come from the Harvard Medical Practice Studies. They were massive reviews of medical records conducted in the 1990s and early 2000s to estimate adverse event rates, that is, rates of medical injury in hospitalised patients. Those studies showed that the elderly experience higher rates of medical injury, not lower rates. Overall, their adverse event rates were nearly double that of younger patients. That groundbreaking research also showed that certain kinds of preventable adverse events, and now we're getting pretty close to that nugget we really want in the denominator, right, which is medical injury caused by negligence. Certain forms of preventable adverse event rates were much more common in the elderly. Harmful errors in medical procedures occurred 5 times more often in the elderly than in the young. Adverse drug events were 4 times more common, and preventable falls in hospitals 10 times more common among the elderly than among younger patients. These findings are plausible. The elderly tend to be sicker, they have more complex, multifactorial illnesses, they're also more fragile and less resilient to medical insults. Older age acts as a sort of a proxy for all those vulnerabilities and risk factors. What higher rates of adverse events among the elderly means for our discussion, and the earlier charts I showed you, is that far from explaining away these differences, estimates based on healthcare utilisation alone almost certainly understate the disproportionately low prevalence of the elderly within medical malpractice claims. We can also triangulate results from a separate line of research to confirm this conclusion. The Harvard Medical Practice Studies also gathered data on malpractice claims in an effort to try to marry together injuries with claims and see who did and didn't sue after sustaining medical injury. In New York, Helen Burston found that elderly patients who sustained medical injury were about a fifth as likely to sue compared to younger patients who sustained injury. In Utah and Colorado, a decade later, we extended this line of analysis to look specifically at patients who experienced adverse events due to negligence. We're matching now to all the claims in those states to try to understand who did and didn't sue and how often. And what we saw was that elder patients, being elderly was a risk factor for not suing. They were much more likely to sustain medical injury and then not do anything about it by way of litigation. Why do the elderly sue much less? We don't know, but there are sort of 2 plausible explanations out there that I think our work helped to propel. One is that their more severe and complex illnesses make it just harder for them and their families to figure out that they've been victims of negligence. They go into the hospital sick, they come out sicker, not always clear what happened. The other plausible explanation relates to the economics of malpractice litigation. These guys. All else equal, the elderly are less attractive plaintiffs because their claims are worth less. Economic damages tend to be lower than for injuries of comparable severity to younger patients, both because lost wages are often off the table and because over 65s used to be, I'm not sure it's still true, often have more complete and deep health insurance. I want to come back to this payment disparity in a moment. Let me go to the next question. What types of medical injury do elderly patients experience and litigate? Our ability to answer this question with the data bank is constrained by the fact that the nature of alleged injuries are described in only a fairly coarse way. We can only differentiate claims by general allegation types, diagnostic error versus judgment error versus communication error, and so on. According to those categories, we don't see substantial differences in the nature of allegations across age groups. Finer-grained information on these allegations and injuries may tell a different story, but the available data tells us the litigation looks pretty similar. What we do see, on the other hand, is that the claims by the elderly involve much more serious injury. "40% of the claims by 60 to 69-year-olds and nearly half of the claims by patients 70 and older involve death. Those are much larger proportions than we see for younger age groups. So I'm referring here to the blue bars and to these yellow bars here. If we combine those two most severe classes of injury, the picture looks like that. About half the claims by patients in their 60s and 60% of the claims by 70-year-olds or older involve major injury or death. Third, how meritorious are malpractice claims by elderly patients, and does compensation tend to track along and reward those meritorious claims? So far, most of the discussion has focused on which types of injuries and which types of plaintiffs get into the system. I want to now move into the next phase of litigation and ask some questions about how well, how accurately the system adjudicates those claims that actually do make it in. Let me just sketch out the conceptual transition here. We can think about an entire pool of potentially valid claims. These are all people in hospitals being injured by negligent medical care. Some small proportion of those actually become claims. But they're not the only claims we see. We also see claims that do not seem to have merit, that don't seem to involve injury, or at least not injury caused by negligence. And those are all going to move through the system and receive compensation at some level or not. And so what we want to try to understand as we move through these transitions is how well is the system doing in separating the wheat from the chaff. About 15 years ago, we studied a national sample of about 1,500 closed malpractice claims. We looked at the insurance files and the medical records associated with those claims and subjected them to intensive review by expert physicians. This approach allowed us to make independent judgments about the merit of those claims, and then to contrast those judgments with how the claims were actually dealt with by the system. What we found was that virtually all of the claims involved an identifiable injury. About 2/3 of the claims were judged to involve medical error by the expert reviewers. 1/3, the reviewers saw no evidence of error. And then about 3/4 of the claims that involved error received compensation, and about a quarter of the claims that were judged not to involve error received compensation. Now, we could have a lively discussion about whether these statistics suggest the system is performing well or poorly. The American Trial Lawyers Association and the AMA both issued press releases on the day this study came out and said exactly what you would expect them to say. The AMA said it was performing terribly and our study had proven it, and the trial lawyers said it's working really well and our study proved it. So glass half full, glass half empty. But sticking for the objective for today, I went back to the data to break out these statistics for the 120 elderly claimants in the sample. Do they look different from the other claimants on these metrics? And the answer is, for the most part, they look very similar. So Y is young and O is over 65. The numbers line up and are very consistent across the sample. The only potential point of difference here is that there were fewer no-error claims by the elderly that received compensation. I have some theories about why that may be, but they're relatively small numbers. Okay, I'm going to keep moving forward. Do elderly patients who win claims receive appropriate levels of compensation? Well, we've already started a little bit on this one. It's well documented that the elderly patients who win claims receive less in compensation than younger patients do. This chart shows mean and median values from the databank over the last 15 years by age group. Comparisons like this are really, really crude because they don't take account of the fact that there are differences in the mixes of injuries in these age groups. Recall, for example, the earlier slide that showed that the elderly were much more severely injured on average than other claimants. The most informative head-to-head analysis here would adjust for as many of those underlying differences between older and younger claimants as we could, especially for injury severity. Everything except age would be the ideal kind of comparison here. I couldn't do that, but I did something like that by running a regression analysis. This figure reports results of an analysis which compared payments across the age groups after adjusting for as many things as I could. Injury severity, gender, type of claim, year, state, and so forth. The way to read the figure is to treat this middle group, the 40 to 59-year-old group, as kind of like a reference group. The bars on either side of that reference group indicate how far the median payment diverges from what you would expect if those other groups were being compensated at the same level as the 40 to 59-year-olds. Plaintiffs under 20 get about 10% more than you might expect. 20 to 39-year-olds get what you would expect. 60 to 69-year-old folks get 13% less, and claimants in the 70-plus group get about 37% less. But this is still not quite right. Even if we could make these claims and claimants look identical on every dimension except for age, well, there's still age. And age is a relevant consideration in assessing damages, at least for some components of damages. The clearest case is future economic loss. This is typically a substantial component of damages cases that involve injuries that are serious and permanent, and future economic losses are anchored to work-life expectancies or to life expectancies. So the older you are, the simple fact is the lower that multiplier is going to be. Non-economic losses, sometimes called pain and suffering, raise more controversial questions. Is there a temporal multiplier on those losses? Should there be? Many courts accept the idea that there is, and they allow counsel to make so-called per diem arguments to the jury about non-economic loss. The logic of this is debatable, but it's not obviously a crazy way to approach the non-economic question. To bring this back to the disparity that we see here, the temporal dimension of damages evaluation means that even after perfect adjustment, it's still reasonable to expect to see lower tort payments for the elderly. How much lower? 40% lower? Those questions kind of reach past the limits of empirical analysis. I'm not dismissing the notion that the elderly are underpaid relative to younger plaintiffs. My point is that it's not possible to make that case empirically, because it summons non-empirical questions about the civil justice system and how it should value losses over the life course. Okay, let me come to the final question here of tort reforms. Dozens of studies over the last 20 years have explored the impact of several widely enacted tort reform measures. And here's the standard list here in blue on the left. Impact is measured by examining effects on various outcomes in the liability system and in the larger healthcare system. And the standard set of outcomes researchers have looked at are here. So you can imagine a big mishmash of crisscrossing lines here with different studies taking on different clusters of tort reforms and looking at different kinds of outcomes. There's about 100 studies now, most of them from the last 10 years, that have engaged in an attempt to understand the effects of tort reform in that way. It's not the time to review that literature in general, but let's pose our specific question for the day. Is there empirical evidence that any of these reforms have differential impacts on the elderly? There is some evidence that the most important and widely studied reform, caps on damages, differentially affects claims by the elderly. And the effect is on claim frequency, surprisingly. Awards to the elderly do not have a higher likelihood of triggering the cap because, remember, the elderly tend to have lower damages, including non-economic damages. But a couple of studies have linked the introduction of caps with a substantial reduction in the frequency of suits by plaintiffs. How can this be? Well, the focus of most caps is non-economic damages. And because a relatively large share of prospective damages in claims by the elderly are tied up in non-economic damages, remember, they're not earners and many have pretty good insurance coverage, caps are going to have a relatively large impact on the value of those claims. Their prospective value to a plaintiff's attorney, being paid on a contingency fee, declines markedly, and they are harder for those injured plaintiffs to move forward. Another distinctive impact has been discussed in the literature, though not actually demonstrated empirically, and that is the effect of attorney fee limits on the viability of claims by the elderly. It's a similar mechanism of action to the one for caps that I just described. Like caps, attorney fee limits essentially reduce the financial value of the claim to a plaintiff's attorney. Very, very few claims go forward without the stewardship of the plaintiff's attorney. So prospective plaintiffs with the lowest value claims are going to be disparately impacted there. And those plaintiffs include the elderly. That's about it. There are no other studies that have tried to consider or considered the role of the elderly, which speaks volumes, I think, in itself. So let me try to take stock here. How common are malpractice claims by elderly patients? Much less common than claims by younger patients on almost any measure. What types of medical injuries do elderly patients litigate? More severe ones. Similar typology, just more severe and much more fatal injury. How meritorious are these claims and how well does the system track that merit? Similar to younger patients. These are not an aberrant set of claims. Do elderly patients who win claims receive appropriate levels of compensation? Inconclusive on the empirics, I would say. Have tort reforms affected the elderly in distinctive ways? When it comes to caps, again, the most important of the reforms, I would say the evidence is leaning towards yes, particularly a powerful study out of Texas that suggested this. Other reforms, who knows? Uncertain. There are some hypothesized relationships there, but they have not been studied well. Okay, let me end by asking the question that all good torts professors should ask, which is why should we care? Why should we care about this? And it does come back to some fairly familiar concepts for those of you who've studied torts, and I understand that's most of you in the room. We look to the tort system to deter dangerous conduct and encourage precaution taking. This is the first point here of deterrence. In the context of healthcare, that should manifest as an incentive to deliver safer care. If there's underclaiming and undercompensation in a particular class of plaintiffs, as we've seen for the elderly, providers may have too little incentives to invest in precautions for that group. This is actually a serious concern, particularly when you pair it with the fact that the elderly are such huge users of healthcare services. Safety incentives in relation to them could be setting the tone for the entire system as a whole, with potential adverse effects for elderly and non-elderly patients. In theory, I think that argument has force. In practice, I'm a deterrence skeptic. I'm less concerned about this one for that reason. Why? Because everything we know empirically about deterrence and the medical liability system suggests that there are fundamental breakdowns in that tort signal. There is very little evidence that tort law improves safety for any group. Full stop. A compromised ability for the elderly to access compensation, on the other hand, is, in my view, a much more serious concern. The empirics that I've talked about this morning help us see that the epicenter of that concern is not necessarily underpayment in those claims that make it into the system and receive compensation. It's zero payment for all those harms that never see the light of day. The inability of elderly patients to access compensation because their claims are of insufficient value to move forward in a contingency fee system is real and is, I would submit to you, grossly unfair. But they are only low-value claims, I hear some of you say. Shouldn't the system's concern be high-value claims? No. The response is wrong on two counts. First, low value isn't the same as low severity, as we've seen. It's the financial consequences of injury to the elderly patient that is low, not the severity of the injury sustained. Severity is high. Second, saying low value claims aren't a compensation priority is a bit like saying public health policy shouldn't pay too much attention to the flu because it's a fairly mild disease. Many low-value uncompensated injuries across the elderly population, almost certainly some, to a large pool of uncompensated injuries and a very serious burden. The physical and emotional impacts of those injuries on elderly patients and their families are in aggregate likely to be very substantial, and we should care a lot about those. By removing barriers to compensation, some of the newer, more innovative reforms I mentioned near the beginning of the talk have some considerable potential to ameliorate the problems the elderly have in accessing compensation through the system. So I'm excited about those developments on the sort of torts horizon. Perhaps my next talk here, Richard can explore how well those reforms are doing in addressing the needs of the elderly in this area. So with that, I'll stop.
Okay.